Welcome again to Legal Aid Queensland's first webinar for 2016. We're very excited because this is actually our second ever webinar. So it's great that we've got you all with us today. Just to check that the technology is all working, could you all please go to the toolbar, which should have automatically popped up on your right hand side, and just put your hand up for me if you can see the hand up section. Okay, great, thank you. All seems to be working well. My name is Catherine and I'm the Community Legal Education Officer at Legal Aid Queensland. So I'll be facilitating most of the webinars that you'll be seeing. Please feel free to look out for more and book into more in the future. So I'm just going to go over a few house rules today. First of all, can everyone please keep their microphones on mute throughout the duration? When it does come to question time, if you have a look in the toolbar in the questions bar, drag that out and you'll be able to type in your questions there. Okay, so the first half of the webinar is going to be presentation time. The second half of the webinar is going to be question time. So if you can please hold your questions until then, that would be great. We'll let you know when to type them in. One other thing is that we've included a handout today. So if everyone can find the handout section and just download the disability support pension impairment final tables, we'll get you to look through this later on in the webinar. Just give everyone a minute to do that now. Okay, we'd like to launch a poll, so if you could please answer yes or no to the question, do you work in rural, regional or remote areas? Just got a few more votes to get and I'll tell you the results in a moment. Okay, great. So 40% of you have said yes. Oh, sorry, just had one more vote come in. 39% of you have said yes, you do live or work in a rural, regional and remote area, and the other 61% have said no, so you're in the Metro Brisbane area. Right, well, I'd like to pass you over to Jim Gibney. He's our senior lawyer in our Civil Justice Services Division, and he's going to speak to you about the 3-hurdle race. Thank you.
Good morning, everybody. I'm told we have 30 minutes to present the material today, and then 25 minutes to field questions. So I'm going to go quite quickly. I have 20 slides to get through in 30 minutes. And the idea is that we'll field your questions at the end. There's no capacity to interrupt me as I'm flying through the presentation. So that's the format. And two other preliminary things about you. I understand there are over 130 registered sites watching this webinar live. So there's quite a range of people. Some of you will know much more than others, and so there's quite a variety of people out there. So forgive me if you already know some of this stuff and it's a little tedious, but we've got a wide audience. The second thing is about me. I've been practicing as a lawyer for a bit over 25 years, 10 years in community legal centres, about 7 of those 10 years in regional remote areas in far north Queensland and North Queensland. 14 years in legal aid, doing various things, and a year in the Human Rights Commission, and that's where I come from when I speak. Now, we'll get straight on to the presentation. So the title today is we're using the idea of a 3-hurdle race to present to you a simple understanding of the eligibility criteria. So the purpose and object of this presentation is to provide to you a simple conceptual model about how a person qualifies for the disability support pension. It's something which we will win today if you come out of this hour having some conceptual model in your head about how the criteria are applied for a person who applies for the disability support pension. The problem is that Social Security Act, which contains the criteria, is complex and labyrinthian. And of course, the Social Security Act covers many things: family, including carers allowances, New Start allowance, widow's allowance, single parent payments, all sorts of things, youth allowance. And the disability support pension is one of the things covered in the legislation. So as the illustration indicates, the Act itself, the Social Security Act itself, is voluminous and complex the way it fits together. And there are many, from a legal point of view, there are many subsections which apply. The disability support pension is covered essentially in Section 94 of the Act. But Section 94 of the Act extends over 10 or 11 pages, and it has subsections which interact with one another. And of course, it includes sections 94 capital A right through to F, and each of them have subsections. So the section itself is difficult to understand, particularly if you're not a lawyer. But as well as that, the rules under the Social Security legislation include other things which we'll cover, like the impairment tables and other rules for the guidelines for active participation in what's called programs of support. There's also policy which is contained in the Guide to Social Security Law. You can access that on the internet, but it's also voluminous. It's about as big as that tome that's illustrated on this slide. So, and on top of that, there's about 30 years of decisions which form precedents about what the various terms and how those sections and subsections and the other statutory instruments which go together to form Social Security law to do with disability support pension, how they all interact and what they mean. So this is why I'm saying the law and the rules are complex and labyrinthian, and they're very hard to understand, even if you're a lawyer. So from the point of view of the person in the street, your clients and mine, when they come up against an adverse decision by Centrelink, when they apply for a disability support pension, and if their application is rejected, it's absolutely baffling. And they'll present to you, and as they present to me, as people who are in great need because of their condition, and their condition impairs their capacity to work. They can't earn a living because of their disability. Their doctors tell them, yes, you're too sick to work, you're too disabled to work. And the doctors will actually verify that in writing in their reports to Centrelink and to others. and provide them with certificates to say that they are not fit to work. And yet when they try to access the Centrelink, the appropriate Centrelink benefit, as they're advised to by their doctors and often as they're advised to by the staff on the counter at the Centrelink office, they're met with a rejection. And how is it that this can be so? And so this is the perspective of what I term the punter, the person who presents to you for assistance and who comes to legal aid and other community legal centres, for instance, for assistance. That's just briefly. There are other issues. Often Centrelink will say, well, you have to have a specialist opinion in writing to back up, to corroborate your claim. Self-report, just what you say about your disability and your impairment, why you can't work, that's not enough. So the problem often is that the person who's applying doesn't have the capacity to get the reports. We commission reports from specialists. They cost somewhere between $1,500 and $5,000 to get a report. So the punter, if you like, doesn't have that economic capacity to commission the reports required. Often they're stuck on a waiting list which can extend years. For instance, a person with osteoarthritis who may have this condition really bad to the point that they can't work. They can't even perhaps move, let alone hold a pencil or work a keyboard to work in their profession. When they haven't got any income, any sufficient income, they can't just go to a rheumatologist and get the necessary reports to corroborate their claim. So they're often waiting on the public health system to see a specialist. They can take 2 to 3 years to get up to a high enough priority before they'll see the specialist. And then, of course, they've got to get the report out of the specialist. So the person can be stuck between the two systems, and this is another problem from the punter's point of view. Another great stopper from a punter's point of view is, especially where they're people with substantial disability and often cognitive impairment, or often using medication and they're not clear thinking, or in many cases people with depression and anxiety or other mental health issues. And when they apply for the disability support pension, up comes before them a series of requirements which are to them like hurdles. It's like hurdles to the horizon, and it's just impossible for them to proceed to meet the requirements. It just looks like an impossible sea of hurdles for them. So what do we suggest? And that's why that brings us to why we're proceeding down this avenue. Rather than just use take the punter's perspective across your desk as workers in community centres or other such places, rather than just be in the position of the punter, as you often are, the first thing to do is to try to identify with your client and see it from their point of view, or in some cases you might just be overwhelmed with the dismay of the client or the grief or despair of the client. So what we're suggesting here is reframe, step out of the punter's perspective and step into what I've termed the decision maker's perspective. So it's useful, we're saying, to step into the shoes of the person at Centrelink who is administering the scheme and making the decisions about whether a person is eligible or not. And this will help you to move forward with your client's problem. And what I've found is, in my practice, I actually use this simplistic model to explain to the client where they are in the system and to keep refocusing the client from the decision maker's perspective to assist to move their application forward rather than just remain in their own, the punter's perspective, remain overwhelmed by the process and dismayed and in a state of despair. Okay, let's move forward ourselves. So from the point of view of the decision maker in Centrelink, this is what it looks like. It looks like a hurdle race, and it's the Centrelink decision maker which must determine who succeeds in the hurdle race, who is actually moving over the hurdles and gets to qualify, gets to the finish line, which is the person qualifies. So this is a rather dramatic illustration I have. You can see there are a lot of people running the race. As far as the clip goes, there appears to be only one person out of all the participants who clears the 3 hurdles. All of the other participants crash on the way towards the finish line, either at the first, second, or the final hurdle. So this is where I'm setting up for you the conceptual model that I'm asking you to adopt, and this is why we've got the models in the format of a hurdle race, a hurdle with 3 sets of criteria. So here I have a very simplistic scheme set out, or illustration of 3 hurdles, where the person running the race, if you like, has to clear the first hurdle, then the second hurdle, then the third hurdle in series to get to the finishing line, to get to qualify for the DSP. Now, if you just look at the bottom of the slide, you'll see the first hurdle is as defined in section 94(1)(a) of the Act, and it's about having a condition or a series of conditions, medical conditions, physical, intellectual, or psychiatric impairment. And then we move to the second hurdle, where the level of the impairment is rated. How impaired is the person? Is it just a minor thing, or is it very severe? And if those 2 hurdles are cleared by the applicant on the evidence which supports the claim, then the person moves to the third hurdle, which is a work test. And only if the person gets over the 3 hurdles do they qualify. Now, I'll just go into a bit more detail, and we'll talk about the first hurdle. So, as I've said, this really is stated in section 94(1)(a) of the Act, the Social Security Act, and it's basically, it says that the person must have a physical, intellectual, or psychiatric impairment. An impairment is defined in another place in the legislation. It means a loss of functional capacity affecting the person's ability to work that results from the condition. So 2 things here. We're talking about impairment mostly. It's not just a condition. For instance, I'm an ordinary human being, and every human being is imperfect. So as I sit before you, I have a number of conditions. I won't go into them, of course, but I've got a spinal condition and heart disease, if you like. But that doesn't entitle me to disability support pension. Just the fact that you have a condition, you must have an impairment from the condition. So, and the impairment is an impairment to work. So there are many things, many impairments that I have. For instance, I'm impaired in my capacity to go kite surfing, or similarly, I have difficulty with what I used to do. Used to race in ocean racing. I can't do that anymore because of my impairments. But they're irrelevant when it comes to this sort of assessment of a person's impairment, because it's an impairment of the capacity to work and earn a living that is being focused on and assessed under this system. So this hurdle really gets down to what I have in quotes at the bottom of the slide, that the person must establish on the evidence first, at the first hurdle, that they have a physical, intellectual or psychological, it should be psychiatric condition, the word's been, it's a misprint. They have a physical, intellectual or psychiatric condition that impairs their capacity to work. Most often people who are applying for disability support pension are able to clear this first hurdle with basic evidence. Then this brings the person to the second hurdle, and this is where the impairment of the capacity to work is measured, if you like, and it's rated. It's rated for its severity, and what is used by the decision maker under the law, the Social Security law, is the impairment tables. And you'll see that on the screen there's a picture of the impairment tables, what they look like, and you have the handout which you can download. You might already have that on your screen. So what's pictured there is the front of the impairment tables. And I've just peeled back the first couple of pages, and it's underneath. You can see there's an actual, there are boxes which have words in a tabular form. So let's proceed and have a look at what these impairment tables are. Okay, first thing to note is that the document has a long legalistic heading. So the heading is in blue at the top of the screen. The front page of the impairment tables is headed Social Security Tables for the Assessment of Work-Related Impairment for Disability Support Pension Determination 2011. So if this document just happened to be on your desk, a person wouldn't immediately think, oh, that's the impairment tables. It looks like some obscure subordinate legislation from some legal office of the government. Well, that's exactly what it is. It is a determination of the Minister for Social Security. Jenny Macklin, made that determination in the end of 2011, and it became incorporated into the Social Security law. It's for those of you who don't know a lot about how law works, it's like a regulation made by the minister, and it attaches, if you like, to the Social Security law, which is passed by the Parliament, such as Section 94. So it's incorporated into the law, even though it's simply something that the minister signed in her office in December 2011. It came into effect in January 2012 and is still part of the legislative scheme for disability support pension. Okay, moving on. It's 65 pages long, and there are 15 tables. So there are individual tables. I've just written there a few of them. So there's a table which relates to the function of the upper limbs, the arms and hands of a person. And table 3 is for the legs and feet. Table 4 is for the spine, functions of the spine, where the person's impairment to work is, the person's capacity to work is impaired by a spinal condition and impairment. Table 5 relates to mental health issues such as anxiety, schizophrenia, depression, bipolar disorder, those sorts of conditions, and the impairment that results from them. Table 7, brain function, such as autism spectrum disorder and acquired brain injury, those sorts of conditions. Intellectual disability is assessed and rated under table 9, and I've picked out table 13, which is about conditions where people have incontinence of the bladder or bowel. And there's functions of consciousness I've just picked. So I picked a random number. Functions of consciousness relate to things like epilepsy or twilight states or impairment of a person's consciousness, even from ischemic heart disease or diabetes, things like that. So briefly, I've just shown you how there are tables. There are 15 of them, and the idea is that the person who is applying must get a rating. Must get a rating on the tables, and as I think I've mentioned, the rating the person must have 20 points or more rating, and it's often an aggregate of points. So the person, for instance, let's say the person's condition was stroke, that they had had a stroke, and so various impairments might come from the stroke. The person might rate, their impairment might rate, for instance, under table 7, their brain function. They might also have impairments of one side of their bodies. So they might have impairments which rate for the leg and their arm and hands. So they get a rating under table 2 and 3. They might also have a speech impairment as a result of the stroke. And there's another table which I haven't mentioned, which is for communication, that's table 8. So the person might pick up, for instance, 5 points because basically they suffer brain fog as a result of the stroke. They might pick up another 5 points each under the tables 2 and 3 for their limbs. But the greatest impact might be in their speech, and they might rate 10 on table 8 for communication. So in that case, the person would have a total rating of 25 points under the impairment tables, but it's made up of increments under the various tables. So that person would clear the second hurdle in relation to having 20 or more points on the impairment tables. So that's an example. So most people, when they're referred to, time's running short. So most people, when they finally find out about the impairment tables, go straight to the tables and start seeing, okay, how does my situation fit in to the tables? Do I score 5, 10, or 20 points for each condition, for the impairment that results from each condition? 5 points is for a mild impact or impairment, 10 points for a moderate, and 20 points for severe. But on this slide, I've taken a snap of the tables, which on the right-hand side of the screen, you'll see this is table 9 for people with intellectual disability, and you'll see how the tables are set out. There's on the left-hand column is the column for points, and in the right-hand column there are descriptors, so that if the person, how they, in this table, how they've been assessed on the standardized intelligence quotient tests, where do they fall, how did they score, and it's quite specific about where the person would rate 0, 5, 10 or 20 on that table for their impairment that results from intellectual disability. The left-hand side is just one page to do with table 5 of the mental health function. It just shows the 20-point box, if you like. So the mental health function goes over 3 or 4 pages, and that's just one page. But so that's where people concentrate when they find the tables and try to work out how the person basically gets over the second hurdle. But hang on, I'm saying not so fast. there are some important things to realise before you just go to the tables themselves. These impairment tables, the determination signed by the Minister in 2011, is made up of three parts. The first part is the title page and the definitions. It goes for about 2 or 3 pages. Part 2 sets out the rules for applying the tables, and this is the thing I'm drawing attention to here. It's the rules for applying the tables which a person like you and me needs to understand, and the client will need to understand not in every detail, but they are very important. So don't just rush to the particular table which relates to the condition your client has. Consider the rules, and here you'll see on the slide I'm really emphasising Rule 6. So the rules are set out. The rules for applying the tables are set out in 11 pages under Part 2 of the rules. They start at page 5, and time is running very short, so I won't be able to go through these rules in detail, but I want to concentrate your attention on Rule 6. For those of you who have access to the impairment tables now, by all means have a look at Rule 6. It starts on page 6 of the impairment tables and goes for 3 pages. But essentially it says that in order to get a rating on the impairment tables for the impairment that results from a person's condition, the condition must be fully diagnosed, fully treated and stabilised. And those terms are defined in Rule 6. And so there are many cases where a person before you who has applied for disability support pension, who is genuinely impaired by severe conditions, they are in a treatment phase in recovering from a trauma or the onset of a condition. And because they're in a treatment phase, they will not be eligible to get a rating on the impairment tables. This is the effect of Section 6 of the table of the rules applying the tables. So the idea is that when a person suffers an injury such as a car crash or the onset of an illness such as multiple sclerosis or a mental health condition or epilepsy or a brain injury, then they are immediately supported by the taxpayer through the welfare system via temporary allowances and income support for a temporary absence from the workplace or inability to work. And so New Start allowance is what they're entitled to, and perhaps sickness, some form of sickness benefit. And that's what the way the welfare system is set up. The person, whilst they're in the treatment and rehabilitation phase, are not eligible. The system is designed that those people are not eligible for disability support, and this is where that distinction is made, basically in Rule 6 for applying the impairment tables, so that the person can only get a rating to get over the second hurdle if their condition is fully diagnosed, treated and stabilised. Only then can they get a rating on the appropriate tables, one of those 15 tables. This is another very difficult thing to get across to your clients, that although they are disabled, impaired, and their doctors certify it, and there's evidence they're doing what they can to manage their condition, they might still be in the treatment phase. It's only when they've completed that phase and their condition is recognised as permanent and cannot be improved by further treatment to get them back to work, it's only then that they will be able to get a rating. Perhaps we can come back to that in the questions if there's still some confusion, but I'll have to keep moving because time is short. All right, the third hurdle. This hurdle, of course, it only becomes relevant if the person has cleared the 2 previous hurdles. it's made up, this third hurdle is made up of two parts. The first part is that the person must show that they have a continuing inability to work in the 2 years following the date of the application, the date that they put in their claim to Centrelink. And this incapacity to work or inability to work, the person has to establish on the facts and the evidence that they cannot work, they have an inability to work 15 hours per week. Now, work is defined as work on wages that are above the relevant minimum wage. It's paid work. So, for instance, I had a client who had substantial intellectual disability, but he was still functional in his own way, and he did work within a so-called sheltered workshop situation, which was supported. And he was quite effective, and he earned a small wage, and he worked like 4 or 5 days a week. So he worked, but he didn't work on the open market in a situation where wages were above the relevant minimum wage. And so although he did, 25, 30 hours a week work, it wasn't work as defined in this context. Anyway, that's the first part of this hurdle. The second part is a requirement for a person to have actively participated in 18 months of programs, job retraining type programs. And these are known as programs of support. And if you just note here, where I have that at the bottom of the page, the second part of the third hurdle, if you like, this applies where the person's impairment is not a severe impairment. Okay, so what does that mean? Severe impairment is defined under the Act to be an impairment which rates 20 points on a single impairment table. So, for instance, the person who I described earlier, who had suffered the stroke, that person is very, very impaired in their capacity to work, but they scored ratings over 4 separate tables, and no single rating on any one table was 20 points. In the illustration I gave, there were 3 tables where the person had a rating of 5 points, and one, the communication table, where they rated 10 points. So that person wouldn't be recognised as having a severe impairment, and that person would be required to clear this third hurdle, not just inability to work 15 hours a week in the open job market, but also that person would be required to complete 18 months of training on these particular programs of support, which are funded programs by the Commonwealth. So you can see that this is a very high hurdle. The third hurdle for most people is very hard to clear. Even if they clear the first 2 hurdles, people often crash at the third hurdle. Okay, so what I just said about, for instance, the person with the stroke, they wouldn't qualify as a person with a severe impairment. They would have to do the programs of support for 18 months and have that credited to them in the Centrelink system. But for a person who does have a severe impairment, a person who is so impaired that they score 20 points on one table, it might be, for instance, they have a very severe impairment from a mental health problem. They might be, for instance, a person who requires long-term care under the mental health system, perhaps even within the psychiatric hospital, for a condition such as schizophrenia. A person who cannot function well at all, and they would score 20 points under Table 5. So such a person is recognised as not in a position to complete the programs of support requirements. So they're exempted. And so it's often very important to consider whether the client not only scores on certain tables, but on any one table, would they be recognised as having a severe impairment and rate 20 points. Okay, so we're coming to the close of my presentation. This slide is just to emphasise for you that there are 3 hurdles. A person must not just proceed through the hurdles to get to the prize to qualify. The person must clear the hurdles, and often the person will, most often in my experience, a person will be rejected because they do not clear the second hurdle where they must show 20-point rating on the impairment tables. So if the person crashes at the second hurdle, that's often it, and the decision maker will say, well, you can't qualify because you don't meet the set of criteria regarding minimum of 20 points. And basically you crash at the second hurdle, so that's it. There's no need to go on and even consider the third hurdle. And so often the punter never even hears about that requirement. So often, even though you can sort out with your client and the person themselves can get over the hurdle if they get more evidence to support their claim to get over the second hurdle and get 20 points, then they're confronted with the third hurdle. And quite often the person's never heard of it. Sometimes they've never even enrolled for the program of support, so they have no credit. And they're just absolutely dismayed that there is a third hurdle and that it's so high. When you're talking to your client, if they're having difficulties back at the second hurdle, it's often a good thing for you to start introducing information about the third hurdle, because even if they might get more evidence and try to clear and scrape over the second hurdle, what would be the point if there's no way in the world, they have no prospect of clearing the third hurdle because they haven't even enrolled, for instance, in a program of support. So keep in mind the third hurdle, although immediately your client might be focused on the second hurdle. That's the point of this slide. Now, all of what I've said assumes that the person before you, the person in question who's applying, meets the other requirements. So there are some other basic requirements which are threshold requirements right at the beginning, and sometimes they do apply, but for instance, the person's under 16 are not eligible for the disability support pension. And similarly, there's a residence requirement, which is basically that the person must be an Australian resident. And resident is defined, as I've got on the right there, in Section 7 of the Act. And the person basically has to be, the basic requirement is a citizen and residing in Australia. But there are many instances where people, for instance, a person might come from New Zealand and migrate to Australia, or from another country, and or they might be born of Australian citizens and who are Australian residents, but they might be born, for instance, in Japan. And so if they're born, I had a client with a severe intellectual and other disabilities who was born in Japan of Australian residents who were living in Japan for a year, some years, and at age 17 she moved to Toowoomba in Queensland to live with her grandparents, because it was much more support in Australia than in Japan for people with disability. So it was very difficult to work through her eligibility, and there was a lot of work to do with her getting through the residence requirement. We actually were successful. We used the section which is the bottom, the dot point at the bottom, but it's very convoluted, and so what I've said all about the 3 hurdles assumes these other threshold requirements have been satisfied. Sometimes they won't be. Okay, so this is just the final slide, which takes us back to summarise the presentation. I'll leave that on the screen, and now we'll move to the questions phase. How are we going for time?
15 minutes.
15 minutes to go. If you want to sit down here.
No, that's all right.
Okay.
I'll help you.
Catherine's just working out how to for you to send questions.
Okay, first question. How often is the disability support pension reviewed once it is approved?
Oh, okay. How often is it reviewed? I see. There's no routine set time in which a successful applicant who is on the DSP comes up for review. It's not as though there's a review set down for everyone every 6 months or 2 years. What has happened recently is because of the stresses on the Treasury to fund the welfare system, there's been changes, such as the determination of the Minister bringing in the impairment tables in 2011. That formed a further restriction of people who are eligible by basically raising the bar and making the requirements harder to meet. But more recently, Scott Morrison was the Minister at the time when, as a result of the political discussions about budget repair and the budget crisis, he announced review of all cases of people who are receiving disability support pension who are under the age of 35. And the idea was that young people should be very much encouraged to work. And so people who have been on the disability support pension, who've been in receipt of the disability support pension for years, some of them for 10 years, all of a sudden were subject to review. And they were reviewed not against the criteria that applied when they were given the disability support pension years ago. No, they were reviewed against the changed goalposts, if you like. And so the impairment tables that applied since January 2012 are used, and often people who did meet the requirements when they first were eligible, maybe 10, 15 years ago, that those criteria no longer apply, and when the 2011 impairment tables are applied, that they cannot meet, they cannot show that their impairment rates are 20 points. So their pension is cancelled. That's the most common form of cancellation at the moment, or review at the moment. And there are thousands of people who are in that category. And many of them are not properly reviewed. So I have, last week I have a client, I have many clients who have this problem. One client last week, 34-year-old single mother, who's been on the pension for more than a decade, the disability support pension, because she has multiple sclerosis and has severe impairments, but they weren't documented. And when she went through the review process, one of her impairments is cognitive impairment, as well as physical impairments to do with the muscles. And she wasn't in a position to properly represent the level of her impairment or get the documentation required for the review. So they found there was no evidence that she scored 20 points under the tables, and her pension was cancelled. So this is a very difficult position that many people are in. That woman was thrown back onto parenting payment, and it's reduced once the children become are of a certain age, and she's required to go out and be subject to the activity tests under New Start. Basically, she's required to go out and hunt for jobs and attend interviews, and this, of course, was impossible with her condition. But because she didn't have the capacity to provide corroborating evidence, she's lost her entitlement on review. There were 8 or 10 questions which were provided to us before the presentation began this morning. A number of them relate to autism spectrum disorder, ASD. There are many people, it's a condition which is increasingly recognised, and many more young people are diagnosed with ASD. Okay, the question is basically, how does a person with ASD qualify? And essentially, this gets down to how do they establish 20 points to get over the second hurdle, if you like, on the impairment tables. And more than that, often it is a question of the third hurdle, because the person with ASD is so affected from their condition that they can't participate in job training programs. There might be evidence that they could not work 15 hours a week in an ordinary job on the marketplace, but how do they get themselves exempt from the requirement to do the POS, the programs of support? And so this essentially means that they have to find or establish that they score 20 points under one table. And of course, it's table 7, which is most used. Table 7 is the table for brain function, and in the introductory notes on page 31 of the impairment tables, it actually mentions that a person with autism spectrum disorder who does not have a low IQ should be assessed under this table. It's very, very clear that it's table 7, which is the relevant table. And if you turn to the 20-point box for severe impairment under table 7, you'll see there are descriptors from A to J, and the person must establish on the evidence severe difficulties in at least one of those descriptors: memory, attention, concentration, problem solving, planning, decision making, comprehension, visuospatial function, behavioural regulation, self-awareness. So the person would have to present evidence from a qualified expert in the field which establishes that they score 20 points, severe difficulty under a number or at least one of those descriptors set out on page 34 of the table. In fact, this is quite difficult because there are not many people who are well versed enough, not many clinicians who are who know enough about ASD and who are specialised enough to give a reliable opinion. And my experience is that often the person will have to hunt for those experts. They're often clinical psychologists, they're not necessarily psychiatrists, because it's very important to understand, I'm sure most of you do, that ASD is not a mental illness. It's not assessed under table 5, which is the mental health function. ASD is a neurological disorder, which is not an illness. It's not a mental illness. Sometimes people with ASD do have mental health issues such as depression and anxiety. It's very common. Some people with ASD also have intellectual disability. So if that were the case, those conditions who might also be assessed under the relevant table. So for a mental health condition and the impairment from that a person with ASD might also have as a comorbid condition, they would get a rating on Table 7 and Table 5. And there are some individuals who also have a low intellect and intellectual disability on top of ASD and mental health comorbidity. They also would get a rating perhaps under Table 9 for intellectual disability. But take care, if a person rates under Table 9, they may not rate under Table 7 for the ASD. So you see it's quite complex. But we need to know more and more about how people with ASD can qualify, and we need to, I put it to you, not just lawyers, but community workers such as yourselves need to understand some of the technicalities here. And perhaps if you have a client with ASD who has great need but is having trouble qualifying, by all means seek legal advice, and that means you can go to BRQ, Basic Rights Queensland, which is a community legal centre in Brisbane, in Fortitude Valley. They have lawyers who can advise you. Of course, they're completely overwhelmed with demand from the punters, and their resources are not very great. So their capacity to advise you is limited. Otherwise, you can come to Legal Aid. Now, Legal Aid is a very large legal firm. We have resources of in excess of $100 million a year in our budget. We've got 13 offices throughout Queensland, but our resources are actually limited in this regard. And what I'm meaning here, to talk straight and explain this, most of our resources are spent on defending people in the criminal law sphere. And another very large component of our work, our resources are spent in family law and children, protection of children. There's only a very small amount of our resources that are allocated to civil law issues, and the Centrelink issue and DSP falls within the ambit of our civil law response. Now, it gets down to that I am the only resource within the whole of Legal Aid. There's one person who works 4 days a week, and that resource is spread across the region from Darwin to Coffs Harbour. So I'm the only Legal Aid resource in that region to provide legal advice and assistance. So it's very difficult for you to access me. But by all means, you can try. Often you might want to access me through an email, and I'll do my best to respond.
The email address that you can use for your questions to Jim or any that aren't answered is webinars@legalaid.qld.gov.au.
Okay. How's that time going?
Last question.
Last question.
Last question.
Okay. Okay. I think the best question to answer at this stage. There are many questions, but there's one question here about mental health issues, and how the question is framed. How can a person get their mental health issues recognised through their DSP application? So let me refer you again. Of course, as I mentioned before, Table 5 is the table which most relates, which is most important for a person with mental health issues. And it's important, the most important thing at the beginning of looking and working through this table is in the, if you like, the fine print on page 22 of the tables. It's got the introduction to Table 5, and there are several dot points. They've tried to make it simple. The third dot point says, like in many other tables, self-report of symptoms alone is insufficient. There must be corroborating evidence of the person's impairment. And then it goes on to elaborate what corroborative evidence is required for a person to get a rating under Table 5. And specifically, the table introduction says that there must be evidence of the person's condition, that is diagnosis, treatment, and is it stable, there must be evidence from a psychiatrist, and it's usually a treating psychiatrist. If not a psychiatrist, there must be evidence provided from the person's treating GP, together with evidence from a clinical psychologist. So a person who might have been managing long-term mental health issues like depression, often you'll find that people present to you, yes, they've been assisted by their GP for 15, 20 years, and the GP has, provided scripts for antidepressants and other medication. Some people have been on antipsychotics, off-label prescriptions for years and years, as well as other antidepressants like Zoloft, etc. And it's just the GP who's written the script time and time again over the years, and the person hasn't had a review by a psychiatrist, because often they can't afford it, and often they've just managed with the medication and managed their life, and there was no occasion for them to actually consult a psychiatrist. And they often shy away from admission to a psychiatric ward in their local public hospital. It's often a dangerous tactic to take that track. So in that case, the person might have applied for the DSP, but all they've had is the GP's a report on the standard Centrelink form, or a letter saying, yes, they verify that this person suffers depression, and they've cared for them for the last 15 years. And that's not enough. It's not going to be enough to even get a rating. What the person must get, if they can't afford or access a psychiatrist, they need a referral to a psychologist. So often the doctor will give that referral and the person will access a psychologist under the Medicare scheme. But often the person will come back with a one-page report from that psychologist after seeing them several times, and they present that to Centrelink. Well, that's not enough, because those people are most often not clinical psychologists. And so it's important to understand the person might need a referral to get the report to support their claim. They have to get a referral and a report from a clinical psychologist. Okay, so they go and get that, and they come back and they want to present that to Centrelink. Well, by this time, it's probably 12 months since they put in their claim. And so the report by this clinical psychologist, which dates 12 months after the date of the claim, is also not good evidence. It's useless, because that clinical psychologist didn't see or know or treat that person at the date of the claim a year ago. And so their report about how that person might be now isn't evidence about how they were at the time of the claim. And that's important to understand, that these assessments and the impairments are all about how the person was at the date of the claim and a short period after. It's like a window that starts on the date of the claim and opens for 13 weeks. And the assessment is all about how the person was or is. Do they meet the criteria in that window at the date of claim? So when it comes to appealing rejections years later, often you'll never get the evidence about that person's mental health condition at the date of the claim, or the 13-week window after the date of the claim. So the upshot is that the person has to abandon the appeal and begin a new claim when they have got the evidence about how they are at the date of the new claim. That's probably all we can do at this stage. Thank you for your attention, and look forward to contact with you in the future.
Thanks very much, Jim. That was a wonderful webinar, and we had a great response with questions. Unfortunately, we didn't get through all of them today. However, if you'd like to email webinars, WEBINARS @legalaid.com.au, legal.qld.gov.au, then we can have a look at those and hopefully answer some within the next few weeks. So thank you again for joining us today, and remember that it has been recorded, so if you know of anyone who might benefit from this webinar, then it's going to be available on our Legal Aid Queensland YouTube channel in the coming months. Thank you very much.